You are Joaquin Hernandez.
Sir.
Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine.
Welcome back to another jaw-dropping session of real courtroom justice. Today's docket? A triple threat of drama, law, and some of the wildest choices you've ever seen. First up, we have a man caught asleep behind the wheel, engine running, beer in the cup holder, and a half-sucked margarita to go. The cop found open containers, slurred speech, and even a warrant for blood. This one's not your average DUI. But it gets better. Judge comes in swinging, laying down the law like a sledgehammer, declaring, "I don't care if there's a burning building, you are not driving." And just when you think it's over, the second case takes a turn for the bizarre. A passenger in a stolen car charged with criminal trespass. The judge is stunned, questioning how someone could be charged for being in a car they didn't even know was stolen. And finally, a third case involving an aspiring nurse, caught on surveillance stealing groceries from the pharmacy where he works. That future career in healthcare? Hanging by a thread. You do not want to miss how these cases unfold. Who's going to walk? Who's about to lose everything? Stick around, because the judge has more than just a gavel in hand. She's got no patience for excuses.
Alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today, promising me you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to say 50 children.
Refuse the test, but the evidence is stacked. Beer, slurred speech, and a warrant for blood. What would you do if you were the judge? Drop a comment.
Do not drive for any reason. If you have a problem with drugs or alcohol, you better address it, because if you don't, I will do it for you, and I promise you're not going to like the way that I do it. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find anything, you're going to stay with me. No more PR bonds.
Your Honor, will he have the opportunity to have an interlock system on his vehicle?
No, he can't drive. I'm not going to let him drive. I mean, he's got multiple open containers, all have consumed allegedly. No. I mean, and I would think that, it's a privilege. And if I get that he understands the awesome privilege at a later date, come back and we can talk. But at this point, no. I will have you come up here, swear to us that you're not going to drive. After that, I'm going to get you the Victoria sign and reset. After that, what is your name, please?
Kia Smith.
I'm sorry?
Smith.
Ms. Smith. You will get to Ms. Smith where she will give you your bond conditions. After that, you'll be free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, you pick up a new case,
No more driving. Not even to save kids from a burning building. Asterisk, the judge just made it crystal clear. Driving is a privilege, not a right.
19, is there a possibility that we can present evidence to the court to permit the interlock?
I am always all ears, but at this point, with all that's in that car, no. But come back at a later day, show me, because it is a privilege. It's not a right. You want a right, take your Dodge Patas and take, but it's an awesome privilege, and that's what it is. Show me how much of an appreciation, proactivity goes a long way, and then we can talk. All right? Yes, ma'am.
Judges, tracking of drugs and alcohol is a random.
Please, on all DWIs for any days.
And
Yeah.
public device or not?
No,
Okay, yes.
no. It's a first. Good morning, Mr. Sarmiento.
Ese señor Sarmiento. Señor Sarmiento.
Buenos días.
You were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do.
They pause right there. Let's talk legal weight. This isn't just a he had a drink situation. This is a trifecta of DUI red flags: open alcohol, slurred speech, and refusal to give a sample. The officer even executed a blood search warrant. That's serious. When you refuse testing, law enforcement often turns to warrants to get what they need. Legally, that refusal can also be used against you in court. It's not a get-out-of-jail-free card. And the judge? She's done with excuses. Not even to save kids from a burning building. That line tells you everything. She's revoking driving privileges then and there. No interlock, no negotiation. That's how high the stakes are. Now, here's a question for you. If you were the judge, would you do the same? Or would you give him a second chance? Drop your take in the comments. Let's debate.
Command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He didn't say he knew he stole it. He just didn't know him, did not give
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Your Honor, the complainant just said that in regard, he did not know the defendant, did not give
I
permission.
understand that, I get that, but, so he's, he's a passenger in the car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't know. When a criminal trespass requires some kind of like notice that, hey man, you know,
So the trespass was, the driver driving into the area and he was this kind of.
he's the passenger, right? I would assume that the driver got charged with UUMB.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, the UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that, it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen.
And Your Honor, first, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was, one moment,
A scratch on the hood.
signs of theft that would lead a reasonable person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So,
And there you have it. 3 cases, 3 lives at a crossroads. A DUI defendant caught mid-nap in a mobile minibar, stripped of his driving privileges on the spot. A passenger tangled up in a stolen car charge, raising real questions about what it means to knowingly trespass. And finally, a young man on the brink of becoming a nurse, now facing theft charges over a few cans of Red Bull and groceries. The law doesn't just judge actions. It evaluates intent, evidence, and sometimes potential. But as the judge made clear, you can't build a future on broken rules. Fire, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more drama, more rulings, and more lessons from the bench coming your way.
Because when I was young and dumb and 17, and, you know, my friend had a CJ7, you know, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
yes.
always broke down. They always had a problem. We always, you know, Jimmy rigged it as well, you know?
in this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complaint saying he doesn't know the defendant in the vehicle.
That no difference.
That goes to the element of without, for the criminal trespass, it goes to with knowledge that it was,
Nah, I'm not, no, I'm sorry. I'm gonna find no probable cause. Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. Mr. Sir, you're charged with theft, aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 12th, 2025, the officer responded to an HEB in Harris County, Texas, in regard to the theft of an employee. The officer made contact with the complainant, the loss prevention investigator. The complainant stated the defendant was an employee of HEB, and the loss prevention employee was notified by a store manager that the defendant was taking Red Bull into the pharmacy without paying, drinking the Red Bulls, and then throwing it away. These acts were verified by video, and the complainant researched the defendant and noticed that when the defendant left his shift, he would have a bag of unpaid grocery items, which select items throughout the store, bring the unpaid items into the pharmacy, wait until the end of his shift, bag the products, and then leave the pharmacy without attempting to pay for the merchandise. The complainant observed the defendant take items without paying in 7 different days. The total was approximately $368.38.
Sir, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to any HEB. Do you understand? If you violate these conditions, you pick up a new case, I'm going to put you in jail. No more PR bonds. You understand, sir? Are you working now? Do you have an income?
I am studying for my board exam. So no.
Studying for board exam for what?
Nursing.
Really? It's not a good way to start, sir. You know, really. Look, I'll give you a lawyer today. Don't pick up any new cases. You got to understand that you got your future ahead of you, man. You want to be a nurse and now you got, come on. Really? I need you to fill out an application for me. Fill it out. Let me take a look at it. I'll give you a lawyer today. Just make smart moves. It's not hard, you know? Really. Come on.
Judge, was that responsive?
Yeah. Do you mind filing no back HEB, please? Any HEB?
Yes.
All right, Judge, counsel is approaching on page 7. Fernandez, come on up.